When your spouse passes away, you cannot sell the property that you co-owned with them. Now, while you were alive, you each co-own that property together, so technically you each own 50-50 of that property. When one of you passes away, their estate owns that property, and then you, the alive one, will have 50% ownership of that. And so when you go to try to sell that property, they're going to pull title and all the information related to it. And they're going to say, hey, this individual that's trying to sell it, they only own half of the property, but their deceased spouse owns, their estate owns the other half of that property. So they'll have to go through the probate process to get that property, that half of that property, out of the deceased spouse's estate and into their full ownership of the spouse that's trying to sell that property. Now, the problem is going to be if it's getting split per the intestate laws, the surviving spouse may not get full ownership of that property. So it kind of depends on how things are set up for the estate planning. Now, it's best to go ahead and get all the probate processes complete. That way you get all the assets out of the estate and into the beneficiaries' names. That way you can figure out how things are going to be managed so that you can sell that property. And you're not waiting until you're trying to go to the closing table to sell that property just to figure out that you have to go through the probate process, which can take up to a year.